As an estate planning attorney, there are kind of a number of things that kind of drive me crazy that people do or that people think that in reality make their estate planning so much more difficult. And one of those is this idea of this perfect beneficiary designation, or that I can just have a beneficiary designation as my entire estate plan. And in reality, that doesn't work, and that belief really causes people often many more problems than they ever would have expected. That type of designation, a beneficiary, only works really if everything is 100% perfect in life, kind of book smarts versus street smarts. And in real life, there's a lot of things that you don't know about, things that happen that you could have never predicted. And there are at least 5 different instances where a beneficiary designation does not work, or it does not do what you thought it would do. Sometimes we call these 5 Ds, but these are things like if you name a beneficiary and they have died, if you have some sort of disagreement. Banks aren't going to want to give money to person A if they think a court might give person B a judgment saying they were supposed to have the money. If there's debts involved, either your debts or extreme debts of the person you tried to leave money to, that could cause these designations to not work the way you thought. Things like divorce actually cause issues, where divorce decrees may say that you actually have to leave a future interest to an ex-spouse, or a person you designated may have to leave money to an ex-spouse. And even disability is something that people need to understand can cause problems with a beneficiary designation, where money may go directly into the name of a person who's disabled. Now they're disqualified from a public benefit, spend the money, have to requalify for a benefit. And so this idea that a beneficiary designation is perfect really isn't true in a variety of common experiences in life. The other thing that you might not realize is that it is not the bank's responsibility to keep your beneficiary designation up to date. Well, what do I mean by that? What I mean is over the years, I can't think of one example where there was maybe a merger and an acquisition, one bank bought by another, where they properly transferred all of the designations from the original bank over to the new bank. And over the years, I've told clients, hey, your bank just got bought, go check to make sure your designation is still on file. And every single time, the new bank says, oh, we must have had a problem in the transition. These days, they say, oh, it must be a problem in the software. And what people don't realize is it is not the bank's responsibility to keep your designation on file or up to date. And when those people die, if that designation was lost, the designation's gone and it doesn't do anything. It's non-existent. In fact, you may not realize that not only in an acquisition, one bank of another may this occur, it could just be a software upgrade where they lose the designations. That's actually more common than any bank is going to tell you. It could be an issue where they're upgrading one account that you have to a different type of account, and a lot of time the designations don't pass over. And so not only do designations that are on file at your death not always do what you expect, but there are a number of instances where your designations get lost and they don't exist on the day of your death, even though you thought they did. And that is why all the time I have clients where either a beneficiary designation didn't do what was expected, and myself and my firm is helping to fix those problems, or people who have beneficiary designations as their only estate plan, they pass away and their family's in because there are other issues that they did not plan for. So it's very important to understand that if you really want to avoid a really bad probate experience, it's important that you have not just beneficiary designations, but that you also have maybe a well-written will. And keep in mind that even if one asset that can't have a beneficiary designation exists at your death, that's going to be probate anyway, right? But if you want to avoid probate altogether, then you really need to have something better in place. Perhaps something like a living trust that does not have the requirement at all to go through a probate process. So if you're ready to check in on your plan, make sure that you've got a good comprehensive plan that addresses all of the issues of beneficiary designations, all of your assets, avoids perhaps a nasty probate, or maybe avoids probate altogether, please come talk to me and my firm. I'm happy to help. You can contact us through our website at cranewooley.law, or you can call at 972-560-6288, and we are happy to help.